everyone. Welcome back to Title IX Insider. Today we have special guests from Consent Awareness Network, Joyce Short, who is the CEO, and Nina Lucas, who is the Chief of Staff. And we're very thrilled to have them here because it's such an important topic when we discuss consent, what it means and its importance, especially here in the United States. And so to get us going, I would love to just invite Joyce and Nina to introduce yourselves very briefly and share what you do at Consent Awareness Network.
Hi. First, I want to start by thanking you sincerely for your interest in our mission to define consent in our laws. I have written a few books on sexual assault. You can see Your Consent right behind me. And it's basically it gives the principles for defining consent in our laws. I'm the CEO and rely very heavily on Nina to do lots of things for us as the Chief of Staff.
Well, I'm Nina Lucas, and as Joyce said, and you said, Dr. Sandi, I am the Chief of Staff. Joyce and I have been working for probably well over 6 years on this mission. Primarily, what I do, in addition to administrative things, is I'm working on the outreach to survivors to bring them in and let them know what the definition of consent is, and working with them with their contacts on changing the law, because a lot of them are very involved, and we want to let everybody know that in any kind of assault, or actually any kind of law, consent is an element of it, and it needs to be defined.
And for everyone out there watching, please remember to like and subscribe to what we are doing here today, especially Title IX Insider. When we touch on all of these important topics, our goal is hopefully to just educate and to help empower individuals to understand the things that are really going on surrounding Title IX, surrounding sexual violence, and of course, consent. And what a better group than to have Joyce and Nina here today to really dive into consent. And so to get us going, I think one of the first questions I have for both of you is to really share, what does consent mean? What does it mean? And what are those misconceptions and misunderstandings that we are seeing out there?
Well, it's actually very easy to define it. And you're right, there are gross misconceptions about it. All sexual assault and rape laws are based on an incorrect concept. And this is not only throughout the United States, but it's around the world. They're based on the concept that conveying agreement means that you consent. And in fact, that concept fails to consider that consent is a noun, and that noun is freely given, knowledgeable, and informed agreement by a person with the capacity to reason. So it's really pretty simple. It's a noun, it's a thing. And instead, our laws are based on the concept that noun is a conveyance. It's what you convey. Quite frankly, what you convey has to do with the verb to consent. You have to have consent in order to convey consent. But our laws are built on the misconception that how you speak and how you comply is indicative of your consent. In fact, if malicious influence is what compels you to respond in a positive way or act in a positive way, you're not consenting, because any form of malicious influence means that you don't really have freely given, knowledgeable, and informed agreement, or that you're not a person with the capacity to reason.
I think maybe in more of a condensed form, you're describing coercion, right? When there is that coercion, there is that manipulation, deceit, it's all of these kind of wrapped up into one, where we really don't have consent, even if the person has allowed the sexual activity to take place. It's not necessarily consent.
Absolutely. And coercion is only one form of what happens during sexual assaults. It could be force, fear, fraud, it could be surprise, it could be coercion. And unfortunately, the concept of coercion is also inaccurately described in most of our laws. In most penal law, coercion means threat of force. And coercion can take place many ways. In fact, force is only one small part of it. Coercion could mean that your professor in school threatens that they're going to give you an F on the subject and you'll lose your scholarship, or that your landlord could be evicting you, or a police officer threatens to arrest you. You know, there could be so many ways that a person could be coerced. There are different types of agreement, and just because you agree doesn't mean that you consent. Agreement can take place in three different ways in sexual conduct. Assent is agreement on the face of it. So if someone deceives you, then you're not consenting. If you were told that you're going to take a shot in order to fight your allergies, and instead they give you a COVID shot, you're not consenting. If you assent, you're not consenting because you're being tricked into your agreement. And agreement under duress is called acquiescence. So when someone agrees under duress, they're acquiescing, they're not consenting. So when a person is coerced, they're not consenting, even though they're agreeing. So we have to make that distinction. Consent is freely given, knowledgeable and informed agreement by a person with the capacity to reason. Assent is not consent. Acquiescence is not consent. But our laws don't make that distinction. And we have to make that change. We have to include the definition for consent, the correct definition for consent, so that we can accurately prosecute sexual assaults and rapes.
One of the things I wanted to point out, which is so very important, because coercive control is so much now popular in the culture, there have been a lot of legal initiatives to describe coercive control, to make it part of domestic violence legal language. And I've gone through probably dozens. Joyce and I have gone through dozens of these initiatives and reviewed the legal language. And some of them do not mention the word consent at all, even though we know coercive control is all about consent violation. And some of them, employ the word consent or consenting several or dozen of times without defining what consent is. And since consent is, again, the basis of so many legal violations, we absolutely need to know what the correct definition is. So juries are not kind of having to make it up, during a sentencing phase. So that's one of the things that we're trying to do, work with these coercive control initiatives to refine them and to make them able to have the result that they want to and they intend to. And that's been a very important part of our work.
Yeah, that's excellent. And I know, Joyce, in your book, I was going through it, and it's so interesting that during the Bill Cosby case, where the jury is asking, give us the definition for consent, give us some information for the Weinstein case so that we understand, what our duty is as jurors to also say someone is guilty or responsible for this behavior. And then the judge returns to, we don't have a definition for consent. Use common sense. And so Nina, you're describing, there's this lack of consent within these definitions of coercion. And then Joyce, you're describing the laws that are important, but we're missing consent.
100%. In New York, a very strange thing that took place that really has a lot of bearing on Title IX. Our laws and penal code state no means no. You have to say no in order to charge somebody with rape or sexual assault. If you didn't say no, or indicate that you were refusing, then they're not going to bring a case. However, in 2015, a law was passed, an education law, that states yes means yes. So we have a conflict here. And 164 times the word consent appears in penal code in New York without a definition for consent. And in education law, the law states that the person, when they say yes, they're consenting. And so what happens in colleges and universities, people think that the law is going to protect them in one way. And when they are raped or sexually assaulted, they go to the police and find out that there's no action that the police can take because the laws don't protect them as they're told they would be protected under Title IX on a college campus.
Right. And that's such a major problem because in many ways, by not having that definition of consent nationally, having this blanket definition, it then almost applies that responsibility to schools and campuses instead. And that shift is so confusing, as you just described, because then you have victims, whether they're the complainant or respondent, coming forward and they think the police will help me, the courts will help me, but then there's no definition there. And then yet schools are asked and required to have a consent definition.
Yeah.
And they're not all the same.
And the no means no, neither the no means no concept of consent or the yes means yes concept of consent is accurate, because it really has nothing to do with what you're conveying or whether or not you express. And that's a term that you're going to see often in law. In fact, in the recent law in Texas, it states very clearly express and comply or go along. So if you express consent or if you go along, then there's absolutely no way that you can possibly prosecute a case. And that's why so few cases are actually prosecuted, because we have the concept of consent so completely wrong. It has nothing to do with what the victim says or what the victim does in terms of compliance. It has to do with whether the offender used malicious influence in order to get that person to comply. And that's what we have to recognize, and can only be recognized if we define consent properly by law.
When you all think about Europe right now, in this year, what we're seeing is the definition of consent automatically now becoming part of law. We're seeing that in France, especially because of Giselle Pellicot's case, right? The Netherlands, Switzerland, Poland. Yet the United States doesn't have a definition. Europe is now pushing forward with consent in their definitions for law. What are your thoughts on it?
They're claiming they are, but they're not. They're doing the same thing. They're actually copying a lot of the laws that exist in the United States. And in the Pellicot case, let me just read my notes here. Okay, in 2025, they passed the law that defines rape and sexual assault as offenses based on whether consent was genuinely given. So again, we're talking about what the victim did and not what the offender did, and not just whether force was used. Okay, so they're recognizing that there are other ways to sexually assault or rape someone other than just force or threat of force. So that's a good thing. But genuinely given can be interpreted in many broad ways. And whether or not the person actually expresses that they consent is not necessarily consistent with whether or not they actually consented. Because if they agreed based on malicious influence, they're not consenting. And that's what is deficient in in the laws in France. Back in 2023, I believe it was, the European Union met in order to establish policy on violence against women. And they unfortunately determined, after quite a back and forth between several nations, I believe there were 27 nations that were involved, and they were unable to agree on what consent was. And the holdouts were France and Germany. And France and Germany recently, so they determined that they would not include rape in their discussion of violence against women. So the most heinous crime, the most heinous violent crime that can exist in society is not being addressed under the European Union's edict on violence against women. All of these countries are trying to make an effort. Australia tried to make an effort. France tried to make an effort. Germany tried to make an effort. But they're still missing the point that you can't determine whether or not a person actually consents by whether or not they express that they consent or they comply, because there are so many reasons, being malicious influences that can happen. So what laws try to do is state provisions that express specific cases in which this is not consent. Okay, so if you use an aggravated form, if you hit somebody over the head with a 2x4, that's not consent. But let me give you an example of Texas. Okay, in Texas, and Summer Willis deserves an award for her efforts. Summer Willis was raped at a fraternity party. And one of the men in the fraternity, gave her a drug that knocked her out. And another man actually raped her. And the authorities in Texas were unable to prosecute because in Texas, that person would have had to have surreptitiously, without her knowledge, given her the drug and raped her. But the fact that it wasn't the same man that gave her the drug and raped her, they were not able to charge. So that's just an example of how writing in provisions that this act qualifies as non-consent. There are so many ways that a person can be raped and sexually assaulted. And you can't tell people by telling them what not to do, what they should be doing. If I were to tell you I'm not a millennial, that's not telling you who I am. If I tell you I'm a gray-haired baby boomer, then you get a sense of who I am. If I tell you I'm not a plumber, I'm not an electrician, do you know that I'm a retired real estate broker and a tennis pro? No, you haven't a concept of who I am. So in order to effectively tell people how to behave and what not to do, they have to understand the underlying cause for why you're telling them that. And you can write 20 different ways that a person qualifies as a sexual, that a victim qualifies as having been sexually assaulted. But that doesn't give you all the thousands of ways that they can be sexually assaulted. And that's what's deficient. If we define consent in our laws, we cover every possible way that a person can be sexually assaulted: by force, by duress, by deception, by coercion, by surprise. So many different types of malicious influence that could impact a person to comply even though they don't consent. And if they're underage, they don't have the capacity to reason to an extent that would qualify as consent. Or if they have a mental deficiency, they would not be able to comply in a way that is considered consent. So we get some of that. We know that if a person has a mental deficiency or if they're underage, they can't consent. But that's not enough. There are so many ways that a person, is deemed consenting when they're not consenting.
I just wanted to say legal language and inclusion is so important. Joyce has often talked about her concept of our laws are like a Swiss cheese umbrella, and they're just full of loopholes that people can slither on through. And that is very true. What Joyce was saying is that if you read the list of sexual assaults, well, any legal language, it's very gruesome, obviously, but it talks about each particular act that can be considered sexual assault. And like she was saying, if it's not in there, then you are out of luck. And we've seen this in all over the place. And I'm thinking about the case in Alaska. And what people do is they say, oh, this is horrible. We have to plug up this loophole. And so they say, okay, we're going to add this instance of sexual assault, which we hadn't considered before, and we're going to put that in the law. But, as Joyce was saying, there are an infinite number of ways or methods that you can be sexually assaulted, and we certainly cannot include them all. And that's why we need to define consent, because then it's very simple. Sexual activity without consent is assault. But because that's not in there, like we have initiatives now against stealthing, condom removal. That was a stopgap law, and that didn't do what it intended to do. Also, a non-consensual intimate image sharing. That law is not doing what it's supposed to do because consent is not defined. And so we want to refine all these laws and include these concepts so that they're going to do what the legislators intended them to do, protect people. Right now, they're pretty much, the laws don't have any teeth.
Thank you for saying that, Nina. So I'm curious, is anyone doing it right?
No.
And okay.
I wish they were, because legislators like to copy the legislation that already is on the books. There's comfort in their being able to defend, they feel that they can defend what they're putting forward because somebody else has done it. And if somebody else has done it, then that makes it okay. Nobody's doing it. We have been in touch with so many legislators around the globe. It's just absurd. And as Nina was saying, okay, we were in a conversation with a legislator in Alaska, and what happened that got her involved was that in Alaska, a lot of people bum rides from other people because they can't afford cars. And so it's not uncommon for people to hitchhike or to ask somebody who they don't know, a stranger, for a ride. And a woman was in a store, man was in the same store. She asked him for a ride and he said, sure, take you for a ride. And boy, did he ever take her for a ride. He tried to strangle her to knock her out. And when she came to, she realized that he had, for lack of a better term, jerked off on her face. It wasn't a crime in Alaska. And so we met with the legislator who was interested in changing the laws in Alaska. And we explained to her the importance of defining consent. We even gave testimony at the hearing on defining consent. Well, fortunately, the good news is they made it illegal to ejaculate on somebody's body without their permission, but they did not define consent.
Wow. Has anyone been close to defining consent? Have any of the countries that you've worked with, seen, or just studied, has anyone come close?
Yes, we worked with a legislator in Arkansas who was wonderful and actually submitted a bill to define consent by law in Arkansas. Now, keep in mind, Alaska and Arkansas are the two states with the highest ratio of rape and sexual assault throughout the country. I beg your pardon. I beg my pardon. Actually, the military has the highest ratio of sexual assault in our country. But the states that have the highest ratio are Alaska and Arkansas. And so we've been in touch with the legislators in both Arkansas and in Alaska. In Arkansas, we got a lot further down the line. The legislator there introduced the bill that consent is a freely given, knowledgeable, and informed agreement by a person with the capacity to reason. So we got to step one. And we also were able to get a senator. When you go to create laws, you have to submit in the United States, in penal law, in the states, you have to submit both the language in the House of Representatives and the Senate. They both have to pass it. Then it goes to the governor. And the governor either signs off on it or doesn't sign off. And if they don't sign off, then it goes back to the legislators who can override the governor. However, we were fortunate that we had both a Senate version and the House of Representatives version, which was identical. And the judiciary, and it went before the Judiciary Committee. Now, the Judiciary Committee is going to either push it forward or not push it forward. And if they don't push it forward, it's basically dead. And so I was asked to give expert testimony in the hearing for the bill in the House of Representatives. And the pushback we got, oh my God, they were dinosaurs. What one legislator actually confided into the legislator that submitted the bill was, well, does this mean that we're going to have to lock up everybody who is at a bar and takes a drunk woman home to have sex with? Yeah, okay.
Right?
But that
Yes.
woman
The
doesn't have
answer
the
is yes.
capacity to reason. That you don't understand that they're committing violating this person. But that was the concept. Oh, we're going to have to lock up all these people that bring drunk women home from bars. Okay. And what's wrong with that? Well, we don't have enough prosecutors to do that. One of the pushbacks that we get also is that we're going to have to, lock so many people up if we do this. No, you're not. Because the minute that you do this, people will understand what consent is. And they're going to stop violating people's consent. That's how laws work. Ruth Bader Ginsburg had a wonderful concept, and I often quote it, and I'm going to quote it in my words, not hers, because that was a few years ago, and we don't use the same terminology today. But basically, the concept is that society's moral reasoning creates our laws, and our laws create society's moral reasoning. So the minute that you establish what consent is by law, then people will understand that they can't violate a person's consent.
Mm-hmm.
I'm glad you brought up the Weinstein and the Cosby cases. I was actually present in the most recent Weinstein case in New York. And at one point, the prosecutor asked Mimi Haley, did you consent to Mr. Weinstein, trying to remember her exact language, penetrating you with his penis? And Mimi said, no, I did not consent to Harvey Weinstein penetrating me with his penis. The defense objected, and the judge did a sidebar with the defense counsel and the prosecutor. The very next morning, because this was after he excused the jury, he brought them forward, they had a discussion, and the prosecutor was told that she could not introduce the concept of consent in that discussion. And the next
Really?
morning,
I'm like, wow, I'm over here. I feel like I'm watching a movie right now, Joyce. I'm so like, I need my popcorn here. But wow.
the next morning, he called in the jury and told the jurors that they could not consider that comment by Mimi Haley in their deliberation.
What was the reasoning behind that?
He didn't give a reason. I can tell you what the reason is.
Go ahead, tell me what.
Because they don't define consent in their laws. In the original Weinstein case, Weinstein was convicted of using coercion to rape Jessica Mann. And he was convicted of using force to sexually assault Mimi Haley. And because he used force, which is an aggravated offense, he got 20 years for what he did to Mimi. For raping Jessica, he got 3 years because it was considered coercion. So our laws are really kind of bizarre. And coercion, the coercion that Jessica described was coercion by force. So it was really bizarre that they did not convict Harvey Weinstein of an aggravated sexual assault, which is rape in the state of New York, against Jessica Mann.
And so, with all of this being said, what is it that United States should be doing next? Like, what is it that what is it that you're working on to help support the fact that we do need consent within our laws?
We're working with legislators to define consent in our laws. Right now, we have both bills in the Assembly and in the Senate pending in Albany. And those bills read very clearly, very simply, consent is a freely given, knowledgeable, and informed agreement by a person with the capacity to reason. Let me explain to you also that in penal law, there is an area called definitions. And the things that actually create a crime are called provisions. Now, New York says the word consent in its provisions 164 times, but in its definitions area, it says nothing about what consent is. So even though you're saying you have to consent, you can have a rape case going on the right side of the hallway, and you can have a rape case going on the left side of the hallway, and they both can have very, very similar fact bases. But the jurors on the right side of the hallway might have a different concept of what consent is than the people on the left side of the hallway. And so on the right side, they dismiss the case. On the left side, they vote for an acquittal, and on the left side, they vote for a conviction. So how does this give us what our U.S. Constitution provides for us, equal protection under the law. If you can't expect that the juror is going to understand what consent is, there is no protection for sexual assault and for rape under our laws, under our present penal law.
So my assumption is that consent should be a civil right and be defined
100%.
as such. And then obviously, for everyone that follows Title IX Consulting Group and our podcast, I think everyone recognizes the fact that education amendments for Title IX will follow suit with whatever civil rights exist. So since there isn't any under consent, for
Yeah.
consent, that's why then we have affirmative consent being described on campuses. And Joyce is going to jump in right now and start talking about affirmative consent. But, and then some campuses don't even describe affirmative consent. And so there is such a, we talk about the penal code system here, Joyce, and you're right. Everyone can look at it very differently depending on what type of crime it is, the judge, the jury, really the types of attorneys you have, and then you can end up with two similar cases with two very different outcomes. But in Title IX, it also applies because in Title IX, we don't have a blanket consent definition.
100%.
So with the responsibility of consent currently in the Title IX world, where the penal code has no consent definition, this is a catastrophe.
100%.
It's really a nightmare.
Did you ever hear of non-affirmative consent?
Non-affirmative consent. No. Do some schools
There is no such animal, is there?
Okay.
It's called an oxymoron.
Mm-hmm.
Right? There is no such thing as non-affirmative consent. So why are we talking about affirmative consent? Of course it's affirmative. Consent has to be affirmative. Yes. But just because you say yes, or just because you comply, doesn't mean that you consent. So,
right. It could have been done out of fear, like you stated, out of coercion, manipulation, lies, everything else. So true.
It's another concept is enthusiastic consent. That's in the law. It's hilarious because okay, then you're not defining enthusiastic. And I always think of a cheerleader, like going, yeah, rah, rah, rah. But again, since consent is so much more, applicable than in the sexual assault realm, it just doesn't make sense. It doesn't apply. If I'm going to sign a legal document or a mortgage, I'm certainly not excited or enthusiastic. Well, perhaps I am, but you know what I mean? It's then there's an argument about, well, how did the person say it? Which again goes back to the words and actions of the victim rather than looking at the potential malicious influence of the offender. So that's another term that's very, very, it makes confusing for people to in a Title IX action or a legal action. How do you determine that? Enthusiasm. That's another ridiculous kind of a legal, maze that we have to go through. This is language I know is in Title IX across, in some places. Another one is, and Joyce, you can jump in on that, is informed consent. In the medical field, obviously, you're always saying, sign this document, informed consent. Well, what's that? What that's implying that consent, there is consent existing somewhere that is not informed, right? And so that's confusing and it's redundant. That's a redundant thing. And the reason why there's so much, we ask about victim blaming and shaming. Why is this in the culture? Why is this, this is so pervasive? How can we handle this? Well, first of all, it's to define consent legally. You're going to understand that it's not about the words and actions of the victim, and the victim's not going to be torn apart on the stand anymore about what they were wearing, doing, their past relationships. So that's going to be, like Joyce said, the culture will change because of that. But yes, this whole hashtag yes means yes, we're fighting against this. Yes means yes is toxic. It's victim blaming. It doesn't take into consideration any malicious influence, but most people think, well, if you said yes, that was consent. And guess what? You're out of luck. Or if you didn't protest, that's consent. And you're just out of luck. And so we're fighting back against something that's very, very entrenched in the culture. And it's very, very much part of consent education. Okay. And if you don't have the correct definition of consent, you're at a loss in consent education. I know that before I met Joyce, I thought the consent issue was resolved or just people understood or it had to be in the law, right? And then I found very sadly in my case that it was not. And so we're working to just push back against all these concepts and it's very, very difficult. I would think that if people are receiving consent education that includes affirmative consent, yes means yes, informed consent, that they have a false sense of security, that they are legally protected, right? But they are not. We are not protected. And so that's an issue. Consent education needs to be bolstered by actually having a legal definition of it.
I'm very happy that you brought up the concept of it being a civil right. Of it having to be a civil right. People recognize consent as a human right. And they think because it's a human right that that's going to help them when they get into a courtroom. But no, it has to be a civil right backed by law. And that's actually stated in the Consent Awareness Network's mission. Our mission is to take the human right of consent and turn it into a civil right backed by law.
Victim blaming and shaming is actually embedded in our law. It's not just people with antiquated notions, although that's part of it. And that's why legal language is so, so very important. And there's been some initiatives I've seen, like, okay, we have to educate juries about sexual assault victims and what happens to them and their trauma so they can render a verdict that's perhaps more just or understandable. I've even seen, so I said, we were talking about it a few weeks ago. They're saying that judges should undergo education about this as well. And going back to my point, we can't educate about consent without defining it. But then again, if we're going to define consent, this kind of education becomes less or actually unnecessary in a big way because we already understand what consent is. And by defining consent, we also understand what it is not. And so this is a really big way to severely tamper down victim blaming and shaming. And so then law enforcement will be having to follow suit, defense attorneys, and the culture too. And Joyce quoted the amazing Ruth Bader Ginsburg. Another thing that Ruth Bader Ginsburg said, we change nothing until we change our laws. And this is so, which is why legal language is so important. And in getting this instituted into our penal code is so vital for human rights, obviously civil rights, rights of women and men, of course. But this is the missing piece. This is the missing link. This is the key. And it's very simple, actually, and very elegant. Define consent, and then it's going to be applied accordingly. And there's going to be real legal reform and change and a better outcome for victims and survivors.
And so we're in 2025, the close of 2025. Why hasn't it been done yet in the US?
So to answer your question regarding why not, what's happening here, largely it's not happening because our legislators don't really understand that this is what has to be done. We need a megaphone to get it across to every legislator across the country. And there are lots of pushbacks that we're getting. We're getting the kind of pushbacks that existed in Arkansas, all the dinosaur concepts, what's going to happen? We're going to have to put all these people in jail. Oh my God, our jails are crowded as they are. Do we want to pay our prosecutors to be focusing on so many rape cases and sexual assault cases that are going to come forward? And no, they're not. People are going to be able to understand where to draw the line and what you can't do.
Mm-hmm. Is it also reputational as well? I mean, when we think about the Epstein files, for example, and you see different names of legislators and politicians involved, is there also concern of just that reputation of individual.
Absolutely. One of the prime concerns for legislators is getting reelected. And if they're in a district where they know that their constituent base is not going to be in favor of this, they're not going to vote positively for it. And so that's a major concern. Major concern is, am I going to get reelected if I support this concept?
Another thing that statistically, some legislators are offenders. It just has to be. And so when this is presented, I'm sure, I don't know, we kind of got the feeling in Arkansas that we certainly don't know, but statistically, somebody is going to be an offender. And, that we're getting a lot of these look back laws now. We had the Adult Survivors Act in New York State, where a lot of people came forward with that. And, if we could define consent and then the state comes up with an Adult Survivors Act or a look back law, that's an issue.
Mm-hmm. Yeah, I know of many cases where individuals come forward and they're going after the politicians of their very own cities and towns and, stating they assaulted me. I'm barely coming forward now. Here I am 20, 30 years later. This is the individual, and they're trying to pass some sort of law against, things such as consent, things such as sexual assault rights, and individuals coming forward, to just kind of expose that. And the Epstein files to me is probably, obviously the most out there in the tabloids and social media. So it really does, for me, paint that picture of what you just described, Nina. They themselves are those perpetrators. So why would they want to pass those laws? Why would they want to have that definition of consent? Because generationally, maybe their sons, their nephews are also doing it. And I'm sure that many individuals in power with money know about it, are covering things up, paying people off. And so there is a generational problem as well.
100%.
Mm-hmm.
Yeah. They're concerned that there's going to be, backlash, and that they're going to be caught up in that backlash.
It's really a nonpartisan or bipartisan issue. So, it's quizzical. We ask why. Why isn't this happening? Why is, consent definition so polarizing with legislators? And this is, part of our assumption that, yeah. And not, of course, talking about anybody in particular. I don't know of anybody in particular at this point. But again, statistically, as far as offenders, they're there somewhere.
Mm-hmm. That is right.
When you look at New York, you can see a lot of the legislators, people in very high levels of government, have been accused of many sex crimes or, things that under, if we define consent properly, that they could have been convicted of a sexual assault.
Mm-hmm.
So, yeah, they don't want it. They don't want it done.
Such a sobering topic when we really dig into consent. So it's as if we're at the bottom of the hill. We have a long way to go to get to that top. And I appreciate what you both do, what Consent Awareness Network does. And for everyone out there, if you have a comment, please be sure to write that in. Remember to like and subscribe to us. I think I'm going to be closing off with just one final question for both of you to answer, which is, if you had that magic wand, you can have anything happen for 2026, what would that one thing be?
Define consent in our laws. And I'm sure that Nina agrees with me.
Right. And if we can get it in, say, New York State, where we have a bill pending, then there's going to be a precedent. We can go to other states, and it's just going to kind of amplify. And, like wildfire, people will say, okay, this is defined in New York. Okay, this is something that we can do. Another wish I would have, or actually something for the benefit of Title IX professionals, is to check out Joyce's book, Your Consent, The Key to Conquering Sexual Assault. It's like a 30-minute read. And I think that that's going to empower and give information to Title IX professionals about the question of consent. And it's going to help them in what they have to do, if I dare say that, just to have this clarification and this explanation, and how it might start to, tilt or shift and help more victims and survivors as well. So I think that would be a great thing to do. We also have a petition that we're trying to get a lot of signatures on to send to legislators to define consent, and so that's something that we have as well. And absolutely, we have to get this defined. If we can get it in one place, we're pretty confident that we can, start to roll it out and affect real change.
Wonderful. Well, my hope is that I can have you both back on in 2026 where we can really dive in even deeper into the Title IX space. But as Nina, you just described, I think Joyce's book would be a wonderful addition for any bookshelf of a Title IX administrator, simply for just understanding consent and being more trauma informed through the definition of consent with their own practices. I do understand that Title IX administrators are a little bit tied to what is out there right now, and it doesn't necessarily help that there is no definition that is clearly stating what consent is. So I also want to support those Title IX administrators watching this now to not think that they'll read the book and say, I can change all the policy to how I believe it should be, which is not correct. And so you still need to follow those regulations. But hopefully, Joyce, Nina, through your help and what you're doing, the legislation, what is happening, the definitions will change and be updated so that way it will trickle over to the Title IX side where administrators can be helped to do the better things. And so with that said, Joyce and Nina, thank you so much for being here today. I truly appreciate and value both of you.
Thank you
Thank
for
you.
having us.